And the AmaZulu Royal princesses lost a court bid to stop the entering of the kraal by the new king. Pietermaritzburg High Court Judge Thomas Ncube struck their urgent application of the royal, arguing that it lacked urgency. The princesses also wanted the court to interdict all processes leading up to the coronation, including the issuing of the certificate of recognition by President Cyril Ramaphosa. The two Zulu princesses also asked the court to interdict Prince Mangosuthu Buthelezi and the KZN Premier from proceeding with all matters related to King Misuzulu's ascending to the throne, including the coronation. Now, in the court papers, they cited that these should be halted until all matters before the courts are finalised. Let's speak to Professor Anthony Diala, who's a director of Center for Legal Integration in Africa at UWC. Prof, thank you so much for your time this afternoon. Were you surprised when the court dismissed that application? Because some were saying the writing was on the wall even before it was made.
Thank you very much for having me. No, I was not surprised. The law is very clear on the mode of selecting the king of the AmaZulu nation. The royal family has to decide, and then the government has to approve the choice of the royal family. And the means of choosing the king is pretty clear. It has to be in accordance with customary law. Now, the customary law, according to the majority opinion, is that the eldest son of the regent, the wife that is married from a royal family, is the one to produce the next king. And I think that is what happened in the case. So I wouldn't say that I'm surprised by that verdict from the court.
So then, how then do you respond at the back of what you've just said to those who are saying that this matter should not even be going to the courts because this is not the correct forum for such matters to be heard?
Yeah, it's a very unfortunate situation. It doesn't tell a good story about the state of customary law in South Africa. Ordinarily, this matter should have been resolved in-house. Prior to the state arrogating the power or issuing the guidance on how to select traditional leaders in South Africa, issues of succession are handled by the royal family in almost a unanimous way. Yes, in the past, we had succession disputes that were settled by force, but generally, most disputes were handled by the royal family. In this case, the matter should never have gone to court because the royal family should have been able to resolve the matter in-house without it having to go to court. One can say that it's the influence of different and perhaps arguably confusing regulations on how to select traditional leaders that may have contributed to this situation. So just to give an example, in the past, the rule of male primogeniture is to the effect that the eldest child of a deceased person will inherit that person's status. So in this case, will become the king. But we see here that that is not the case because the successor was chosen from the royal wife, which is the third wife, not the first wife of the late king. So that's what could have possibly contributed to these succession tussles.
Now, when you listen to some of the arguments that were made in court, the president's lawyers, for example, because he was cited as a respondent there, saying that this was a self-created crisis. Was it?
Well, self-created crisis, how would you say that it's a self-created crisis? A self-created crisis is one in which perhaps maybe the late king married from two royal families. Then you could say there is a problem in deciding which of the two royal families will produce the successor to the king. So I don't know how it can be described as a self-created crisis. If there is a will that stipulates what will happen.
It was in the context of the urgency of it yesterday, that this was a self-created crisis, not necessarily going into the merits of the matter.
Yeah, I mean, this should have been handled long before. The urgent interdict that was brought just hours to the coronation, it's completely uncalled for. I don't know what was happening all this while, that challenge was not brought much earlier. But who knows what people are thinking.
What is your sense here? Do you think this could go to a higher court, and what are the chances of it standing?
Well, I can only speak from a legal angle as to what is likely to happen if the matter is challenged further. If it is challenged further, what will happen is this. The court will be interested in knowing two things. One, was the proper procedure followed for the selection and the inauguration of the new king? Secondly, was the selection procedure in accordance with customary law? Once the court is satisfied that these two elements are present, then the challenge is very, very much likely to not succeed. That's what I think.
It's going to be interesting to see then how this matter unfolds. Thank you so much, Prof, for your time this afternoon. We do appreciate it. That is Professor Anthony Diala, Director of Center for Legal Integration in Africa at UWC.